I'm Jeffrey Rosen from the National Constitution Center in the New Republic, and I'm here with Justice Ruth Bader Ginsburg in the Lawyers' Lounge of the Supreme Court. What is the majority opinion or dissent that you've written that you think has done the most to advance civil liberties?
Jeff, it's like saying which of my 4 grandchildren do I prefer. There have been so many. Well, in the women's rights area, you can think of the Virginia Military Institute case. So many people said to me, why would women want to go to that school? I wouldn't, and perhaps you, a man, wouldn't either. But there are women who are fully ready, willing, and able to have that form of education, so why should they be held back by artificial barriers? I must say that the VMI case was preceded many years earlier by Justice O'Connor's decision, her very first year on the bench, in a case called Mississippi University for Women against Hogan. That was a case about a man who wanted to go to Mississippi University for Women to take nursing. It was the best nursing school in the area, but he couldn't go because he was a man. Same with VMI later on. There was a decision on the civil side that didn't get much press. It's called M.L.B. The court's precedent was that if you are too poor to afford counsel or to afford a transcript in a felony case, the state must provide legal assistance for you. M.L.B. was a woman who was facing a deprivation of parental rights proceeding. She was charged by the state with being an unfit mother. She lost in the first instance, and she wanted to appeal. But the state's rule was to appeal, you must purchase a transcript, and she didn't have funds to pay for the transcript. It was technically a civil case, but I was able to persuade a majority of the court that depriving a parent of parental status is as devastating as a criminal conviction. And so the court decided if she can't get an appeal without a transcript, then the state must give her the transcript. That was changing the line, the rigid separation of criminal cases on the one hand with a right to paid counsel paid by the state, transcript paid by the state, in civil cases where you do not have those rights, you have to be able to pay. So I thought M.L.B. was a significant case in that regard, getting court to think about what is the impact of being declared a non-parent on a woman like M.L.B. Well, it is devastating. Much worse than 6 months in jail.
And for dissents, your Carhart and Stenberg dissent is quite memorable.
The Carhart dissent was the partial birth abortion case. And there what concerned me about the court's attitude, they were looking at the woman as not really an adult individual. The opinion said, the woman will live to regret her choice. That was not anything that this court should have thought or said. Women are fully adult. They're able to make decisions about their own life's course, no less than men are. So yes, I thought that in Carhart, the court was way out of line. It was a new form of we have to protect the woman against her own misjudgment.
It's galvanizing to hear you speak so passionately, and there's been a notable change in your decisions and in your public appearances since you became Senior Associate Justice. When you were appointed, many called you a minimalist, a judge's judge, and said you were cautious. But in recent years, you've really found your voice and have become a liberal icon across the country. Why did you change?
Jeff, I don't think I changed. I think the composition of the court changed. Think of 2006 when Justice O'Connor left us. Every case in which the court divided 5-4, and I was in the 4. If Justice O'Connor had remained, I would have been in the 5. So I don't think that my jurisprudence has changed, but the issues coming before the court are getting a different reception than they had when Justice O'Connor was a member. And then I had a very good model to follow. When we divided 5-4, the most senior member was almost always Justice Stevens. Justice Stevens was very fair in assigning dissents. I should say, add to that, he kept most of them himself. So that was in Citizens United, in Shelby County, the Voting Rights Act case. It was a consensus that I should write those dissents, just as Justice Stevens wrote the dissent in Citizens United. So I try to be fair so no one ends up with dull cases while another one has exciting cases. And I do take I suppose, the most watched cases.